Judicial Watch. Records obtained in court-ordered discovery reveal Obama White House tracking FOIA requests for Clinton emails. Obama knew, the Obama White House knew that there was an issue about Clinton emails, and yet they continued the cover-up. This is what had happened. There was this left-wing group, the Citizens for Responsibility and Ethics in Washington, a watchdog group modeled on Judicial Watch, that had asked for Clinton emails, including personal account emails, alias account emails. So this request was noted within the State Department. It was right on the money in terms of targeting Hillary Clinton's email server. And they sat on it. And they kicked it around among the lawyers there. It involved Cheryl Mills, knew about it. Heather Samuelson, White House liaison at the State Department under Hillary Clinton. Later became her private lawyer, involved in deleting the emails that Hillary Clinton improperly took from the State Department. By improperly took, I mean stole. She knew about it. They all knew about this request for her emails. So the request occurred in 2012. You know who else knew about this request for her emails? The White House counsel under Barack Obama. These emails were disclosed to us as a result of not FOIA, but discovery, court-ordered discovery. You know, when you're sued and you have to turn over records to the other side, it's that type of discovery. Cheryl Walter, Director of the State Department's Office of Information Programs and Services, writes to other officials, White House called. WH called. Have we received a FOIA request from Crew on the topic of personal use of email by senior officials? Apparently other agencies have. If we have it, can you give me the details so I can call White House back? I think they'd like it on a quick turnaround. They knew this was coming. In the same email chain, she emails Heather Samuelson, as I say, the White House lawyer. Excuse me, the White House liaison who became Hillary Clinton's private lawyer after she left. Hi Heather, copy attached. It was in our significant weekly FOIA report. As a practical matter, given our workload, it won't be processed for some months, so they were just going to stall just as a matter of course. Let me know if there are any particular sensitivities. And then on January 10th, 2013, Walters writes to Samuelson that she is not including personal accounts in the FOIA request search. Hi Heather, did you ever get any intel, Ray, whether other agencies are doing, Ray, this FOIA request that seeks records about the number of email accounts associated with the secretary? So she wants guidance from Samuelson about what she should do, because she's saying, I may talk to the requester about basically trying to get around their request. Samuelson responds, White House counsel was looking into this for me. I will circle back with them now to see if they have any further guidance. That's your smoking gun. The White House was running the FOIA response about whether there were secret Hillary Clinton email accounts. And the response on May 10th, 2013 was a lie. No records responsive to your request were located. They knew exactly what was going on. If this doesn't tell you that the Obama White House wasn't orchestrating, certainly they had a lot of help, but they were orchestrating the cover-up on the Clinton emails, I don't know what will. The court wanted answers as to who was behind the government cover-up. Well, we found the answers. The Obama White House counsel's office. We've already exposed the FBI, top FBI official nominally in charge of the Clinton email investigation. We already told you how he admitted to us under oath in writing that they found Clinton emails in the Obama White House Executive Office of the President. Again, showing Obama knew. If you want to know why Hillary Clinton wasn't prosecuted, it is because the Obama White House was involved in the Clinton email cover-up. To prosecute Hillary Clinton would have been to implicate the President of the United States and people around him. And certainly if you're Hillary Clinton, you'd be like, you want to prosecute me for sending out these emails, running the system the way I was? I was communicating with the President on this system. I'm going to bring him as a witness in my favor. It wasn't just the Clinton email scandal wasn't just the Clinton email scandal. It was a White House scandal. It was a State Department scandal. It was a DOJ scandal. It was an FBI scandal, etc. And we're still getting the testimony. We just had testimony of, who else did we take up? Jake Sullivan. Jake Sullivan was a top official for a top Hillary Clinton aide during her tenure at the State Department. I think our lawyers flew up to New Hampshire to question him a few weeks ago. We released the records. We released the transcript of the deposition recently, so you can go and look at the transcript. And he admitted that both he and Hillary used unsecured personal emails for official State Department business. So it wasn't just Hillary Clinton doing this, it was other aides in the State Department. Including classified information, obviously. We questioned him about classified information he sent. When I sent this email, he told us, my best judgment was that none of the material in it was classified, and I felt comfortable sending the email on an unclassified system. The material has subsequently been up-classified, but at the time that I sent it, I do not believe that it was classified. Well, material isn't up-classified. It's recognized as classified. You know, there are 4.5 million people with national security clearances, and I'm sure many of you are watching right now, and you know exactly what I mean. It's your responsibility, certainly at that senior level, to know what is classified and not classified. And material is classified whether or not it's marked classified. And it's your obligation as a government official or someone with a national security clearance to protect that information and to transmit it over unsecure communications devices or through unsecure communication means is a violation of law. Sullivan said in his deposition he had not been concerned about Clinton's use of a non-governmental email account because it wasn't part of his job. There you go, that's bravery. Like Secretary Clinton has said herself, I wish she had used the State Department account. It wasn't really part of my job to be thinking about Secretary Clinton's emails, so I don't think I sort of fell down directly in my job, but I do wish I had thought of it during the time we were at State. Of course, I mean, what human being at this point wouldn't have thought of it? So you can read the entire deposition. It's up on our website. I'd put the video out there for you, but I'm not allowed to because the federal court ruled it's under seal. So the court who granted us the discovery, typically when you get deposed under oath, many deponents are videotaped. And certainly in a case like this, it's the ordinary course. But the Justice Department, this Justice Department and this State Department came in and asked the judge to make sure these videotapes aren't released publicly. And we opposed that, but the court denied, unfortunately, the release of the videos for now, but left the door open for reconsideration. He said, the court does not foreclose future releases of audio-visual recordings in this or other cases. Judicial Watch may move to unseal portions of these recordings relied upon in future court filings. So too may it use the video recordings at trial consistent with the federal rules of evidence. So maybe this material will become publicly available via video, but in the meantime, you can gain access to this information on our website, the transcript available at the Judicial Watch website.